Ms. Feely's free to call her. It's not that that's a witness for whom you haven't received notice. It's your witness. I hear you on the child hearsay notice in that Ms. Feely didn't provide it, but one, she didn't get the Brady notice until maybe Friday at the earliest, only because it only came out then. I'm not faulting the state, but I don't know that a basis to exclude Investigator Harding would be that Ms. Feely didn't at light speed provide 820 notice, especially since it is known to the state. And that's not the standard, because Ms. Feely likely definitely knew that Serenity's aunt and Serenity's sister were going to be child hearsay witnesses, and obviously the police officer. But don't base your argument on the hearsay notice. Tell me why you think it would be improper for Ms. Feely to call Investigator Harding to my line of questioning. Investigator Harding, did Serenity Mathis say anything specifically about whether Mr. Higginsbottom touched her buttocks? Yes, she said she didn't remember that happened. She didn't testify, I don't remember that happened. She didn't say it did happen, but she didn't testify, I don't remember to it. So it's a little inconsistent with what she said. It's not profoundly inconsistent, but it's still, it seems inconsistent enough. I guess, though, to your point, Ms. Feely asked no questions of Serenity, and so didn't say, well, did you ever tell anyone that X happened? And the test has been loosened a bit with the newer evidence code. I don't think that the witness has to be confronted chapter and verse, but there was zero confrontation because there was no cross-examination. So I guess, Ms. Feely, tell me how that is a prior inconsistent statement. I guess I sort of see how it's inconsistent, but how you laid sufficient Section 613 groundwork to be able to impeach with that without even calling it to the witness's attention. And again, I don't know that the standard anymore is, do you remember on this specific date with this specific person you said X? I think it can be as general as, didn't you in the past say, have you ever told anyone that Mr. Higginsbottom touched you on the butt? Obviously, you didn't do that because you asked no questions at all. So this is an easier, either you don't have to do anything and you can impeach, or you have to do something because you did nothing because you, for all sorts of strategic reasons, asked no questions of the alleged victim.
Certainly the court could see why I would not want to elicit that element of account in the indictment when, in my opinion, there was no testimony of that. But tomorrow, the jury will be hearing the forensic in which she does make mention of that. So It's our position that this isn't impeachment so much as evidence that as recently as Friday, when she was interviewed for an hour and a half at her home, she did not recall that. So it's not impeaching her testimony. We're framing it differently than impeachment.
What are you framing it as?
Just that she did not remember when she spoke with the DA's office.
But that'd be hearsay. It's not hearsay if you're impeaching. I mean, that's the way someone's out of court statement that you're offering for the truth of the matter asserted, which is hearsay, comes in the context of a prior inconsistent statement is Rule 613. It is, I mean, that's an exception that has been drawn. But in order to use a prior inconsistent statement, the witness needs to be given a chance to say, oh, yeah, I said it before, or now that you've shown me, now I remember. I mean, it's the classic, well, now that you've seen this, does this change your recollection? Nope, it never happened. I don't know why I said it back then, but nothing along those lines occurred.
I'm not sure how I would have been able to confront her with that.
Well, I mean, there are lots of different ways. That's not an easy way to press play on a video. I don't mean to suggest that's the only way of doing it. A more typical way would be, did you tell anyone you didn't, have you ever told anyone you didn't remember? And if she says, no, I would have never said I didn't remember, then in comes Harding to say, well, actually, she told me that 4 days ago. Ms. Serenity Mathis didn't have a chance to either have a recollection refreshed or at least explain what appears to be an inconsistency. I haven't seen the video, but presumably she's going to say on this August 31st date, he was touching me here, touching me there, and he touched me on the butt. I don't know that it's so clear from her testimony yesterday that she didn't say something like that, but clearly count one, there was no mention of conduct about count one. And Mr. Jordan probed with one question. Do you remember anything happening before this date? I don't. So, what does, if we focus on that, the count one, what does investigator Harding add? Wouldn't that be a prior consistent statement?
Right. We were much more concerned with count two, but I'm waiting to hear back from, I may have a more coherent answer if we could come back to this after the charge conference.
No, let's do that. But understand my question / concern. It would be how, given that you chose not to cross-examine Serenity Mathis, you could then impeach her about a statement that you never asked her about. Okay. And let your appellate team do its thing.
Thank you.
All right. Let's do the charge conference.
Your Honor, before we begin the charge conference, I told Mr. Atkins that he's being barred from the courtroom.
He was wondering why he couldn't get in.
Yes.
Yeah, I had enough of that speaker.
That was my delay, Your Honor, and I apologize for that.
All right, let me get our jury charge up. So Mr. Higginsbottom is downstairs in the queue. The next bus that leaves, he's on it. Do you give him like a gold ticket so he can go to the front of the line?
No.
What if there are 13 people and he's number 13?
You know, you should go.
How do they know that?
So
Okay, and you told people who are responsible for transport?
I just told you as a detention.
Pardon me?
Detention officers.
Okay,
There was no transport officer.
okay, but the detention folks will know, hey, he's priority. Like the luggage that has the little tag on. Okay, good.
And, you know what you were saying? She's still in call, so she's at jail now.
Oh, she's out at the jail? Okay, so let's pause. I'll be right back. I'm gonna call, she's in the perfect place for this phone call. Oh, she's out there because what's happening tomorrow, I bet.
It's up that floor.
Okay, I'm gonna talk to her. But let me share screen. So we're teed up. Excellent.
5-0.
Does he get to go with you?
He's gonna go with.
Field trip.
When we done, we're gonna send it to the.
All right, let's get back on the record in State versus Higginsbottom. Again, Mr. Higginsbottom is not here in court. He has waived his presence for our discussion about Investigator Harding and our charge conference. I have a quick update to get this into the record. Deputy Gordon and his colleague will be personally escorting Mr. Higginsbottom back to the county jail. They will take him from the Sally Port directly to the medical unit, and they will film the administration of the medication to Mr. Higginsbottom. Mr. Higginsbottom, of course, is free to refuse it, but he will be doing so on camera. We'll see how that goes. Charge conference. If you look on the screen, you will see, let me make that small. Ms. Feely has suffered through this before, but for you two, what I do is jump to the places where I had questions or concerns. If in doing so, I skip over an area that was of concern for you, then say, Judge, could we go back to X and we'll talk about that. But I'm going to assume if I don't hear from you that the things I don't ask about or discuss, you had no issue with. I use pattern language as a template, but I often try to put it into plain language. So if I say I use the pattern for presumption of innocence, I did, but I've plain languaged it. I won't remove a concept, but I might remove a 19-syllable word and replace it with a 2-syllable word. All right, the first area I have is under grave suspicion. I learned in preparing for our judges conference that while a few cases have said that that's not a mandatory term, charge, a judge who said, I never give it because one case said that, that judge was chastised by the Supreme Court saying, well, you know what? There may be times when you need to give it. I think as modified, it's appropriate. I don't think this is a case where there's only a speculation, but I do think that there is at a minimum grave suspicion, but that's not enough. And so I think I should give it, but as edited. Ms. Feely, any objection to that?
No, you are.
Okay, I'll keep that edit in. In other words, what I have struck through will be gone in the final version. Next is stipulation. I'm not aware of any. Ms. Niles included that because she never knows exactly what's going to happen during the course of the trial. And one or both sides asked for it, but I don't think I know there haven't been any. I don't foresee any coming. You agree, Mr. Jordan?
Yes, Your Honor.
Ms. Feely?
Yes.
Okay. Defendant's choice not to testify. I've only highlighted that because I won't give it if he does testify. So that is conditional on Mr. Higginsbottom's choice. So far, there's been no limited use evidence. I don't see that happening either. There are no convictions that people are getting in. I guess in theory, if Mr. Higginsbottom testifies and he is impeached with his prior, maybe that's a limited use, but right now I don't see a need for that charge. If circumstances change, let me know. Given Ms. Feely's forecast that she would call maybe Harding and maybe her client, I don't think good character of defendant is needed either, because there don't seem to be any witnesses on the horizon for that. Monique Mathis may have given off the aura of he's a good guy and I don't believe my niece, but she didn't say anything to that effect. So I don't think that's a charge I ought to give. Mr. Jordan?
Agree, Your Honor.
Ms. Feely?
Agree.
presumptions and inferences, that is a pattern charge. To me, it's a confusing one, and I don't think it's needed in this case. It's not the kind of case where I didn't realize if you pull a trigger, a bullet comes out of the gun. If you can articulate a reason for me to give presumptions and inferences, Mr. Jordan, if you requested it, I'll give it, but I'm inclined to keep it out.
Yes, Your Honor. At this time, the state has no rationale for why that should be given as a jury instruction.
Ms. Feely?
No objection to removing it.
Okay. A party to a crime, I'm not giving. Any objection? Mr. Jordan?
No objection.
Ms. Feely?
No, Your Honor.
Okay. Voluntary intoxication, same. There hasn't been any evidence to that effect. Maybe if Mr. Higginsbottom testifies, things could bend in that direction, but otherwise I don't see a basis for it.
Your Honor, there will be, at least the state anticipates in the forensic interview, Serenity Mathis will state in that interview that she believes that Curtis Higginsbottom was high at the time of the August 31st incident. So we would ask for the voluntary intoxication notice used for prior jury charge.
Ms. Feely?
We still need to discuss what of the forensic interview needs to be redacted. as
Okay.
well. I don't have the timestamps on me right now, but if that comes in, then I suppose there could be a basis for it, but
I'm going to turn it green as a maybe. I'll need to hear the interview that gets played to the jury, but I guess another thing we can talk about when we're done with the charge conference is that video. If things need to not be played, we need to talk about it now and not tomorrow morning.
And we do have a time hack on that, Your Honor, so we can jump forward whenever the court is ready.
Okay. I thought there was a new pattern charge that our plain language instruction team did for child molestation and aggravated child molestation. I didn't have a chance to look for it this morning. But that's what that new PLI is, that obviously those two charges need to be given unless there's a directed verdict as to aggravated child molestation. There may be a new and improved version, and I'll share those with you if I find them. Dates in indictment. I struck out the language about specific allegation because there is no specific allegation of the date. There's this reference to the statute of limitations, and it's confusing to the jury. They're not going to know if it's within the statute of limitations unless we then tell them what it is. So my thought is, if I'm giving the dates in indictment charge, which makes sense if count one survives, then, and maybe counts 2, 3, and 4, because there's been sort of a August 31st, September 1. Now granted, those are adjacent days, but there may be a little confusion in the juror's mind. It is a correct statement of the law to tell the jury, don't sweat it if the indictment says one date and the proof is of another date. Unless, of course, it's outside the statute of limitations, and counts 2 through 4, that's not an issue. If everyone agrees that there is no allegation of anything that would be outside any statute of limitations, then the easy fix is I only give the first sentence. In proving the date of a crime, the state is not restricted to proof of the dates alleged in the indictment. I don't need to say anything else. If there is some concern, this would be a defense concern, that count one could be proven by evidence that is outside the statute of limitations, then we need to include the stuff about statute of limitations. I just didn't know off the top of my head what the statute of limitations was for aggravated child molestation. I just remember that for child sex crimes, it's very elastic because of the late recall, whatever they call it, when someone is 30 and say, wait a minute, this happened to me 25 years ago.
Your Honor, I don't believe that there is a statute of limitations for aggravated child molestation and child molestation, but I want to make sure that I'm stating that correctly to the court, so I will pull up the statute. Okay.
Ms. Feely, if I just gave the first sentence, so what I've highlighted in gray there, do you think that's adequate to address a concern or question the jurors may have about, well, wait, what do we do with these dates?
yeah, sure.
You don't think there's a statute of limitations issue? Okay. That's all I had in terms of questions or concerns. So to recap, defendant's choice not to testify will stay in, assuming Mr. Higginsbottom, 1, comes back tomorrow, and 2, chooses not to testify. And voluntary intoxication may come in. We'll see what part of the video is played and what it says. Then I may get the new and improved versions of the 2 offense charges. And I think that's it. Ms. Feely, did you have any additions or deletions that you wanted?
No, Your Honor.
Okay. Mr. Jordan?
If I may confirm with Mr. No, Your Honor.
All right, then I will do draft number 2 that will become final once we know a little bit more about how tomorrow's going to flow. Ms. Feely, tell me the subject matters or matter of the forensic interview that you think should be excluded. And it sounds like Mr. Jordan's in a good position to find those and play those.
I don't think there's too much problematic, but the reference to drug use, certainly we would ask to redact.
That's it?
I believe so. I'm going to give it another listen this evening, but nothing that I remember.
Okay. Mr. Jordan, are you in a position to play the part or parts of the interview that relate to that?
I am, Your Honor.
All right, let me stop sharing so you can share.
Is there anything else that you wanted to talk about? I know you told me there was one more thing, so
It's a whole bunch of stuff I gotta get off my chest.
okay.
Chastity.
Charity.
Charity.
It's okay.
What is charity?
Can you pause for a sec?
Yes, Your Honor.
Is that a sheet of plexiglass between them? This is like a COVID protection?
Yes, Your Honor. They kept that up, I believe, through, they may have only taken it down recently because I went to Children's Advocacy Center to watch a forensic interview. So I believe that they had that out for about 2 years.
Okay, so that's what that line is that's in the middle of the screen.
Yes, Your Honor.
Okay.
Social worker, when I was talking to her that day, not the day. You have a nice charity. That night, he was high. He was high.
Okay.
You get a point?
I understand what you mean by high. So, when you say high, what do you think the person was on to be high?
Curtis Higginsbottom was high that night.
Okay, and what does high mean to you?
Only like drugs,
Okay,
I think.
okay. Have you ever seen him do drugs before?
No,
Okay. What made you think that he was high?
like his eyeballs like
You kind of like rolled your eyes and kind of.
they're like his eyes a little low, like
Okay.
a little, not like a lot low, but like a little low.
Okay.
And he was doing that to me.
And what was he doing to you, Sean?
Finger.
And Your Honor, that is, I believe that's the only extent of the forensic interview that specifically mentions drugs or being high.
Tell me what you think the relevance is of of Serenity Mathis's opinion. Well, it's an assertion, but then I think he was high. That exchange that she had with the interviewer.
Your Honor, I think that it would be a present sense impression, if anything else, of how Mr. Higginsbottom looked at the time that the molestation happened. And it also couples with the testimony that she's already presented before the court that Mr. Higginsbottom's eyes were low when he came into the bedroom and the molestation occurred. So it's a contextual detail as well, Your Honor.
Can you rewind 10 seconds and play it again?
Yes, Your Honor.
Like his eyeballs like
You kind of like rolled your eyes and kind of.
they're like his eyes a little low, like
Okay.
a little, not like a lot low, but like a little low.
Okay.
And he was doing that to me.
And what was he doing to you, Sean?
So you can pause now. It seems like you can get the eyes were low. That's the very end. The interviewer said, well, what, you said hi. What do you mean by that? What did it seem like? We can cut out all of the, he was high, Mr. Curtis Higginsbottom was high. What do you mean by high? And you still get what I think is a valid contextual detail that connects an interview from whenever this was, many months ago, to testimony yesterday, because I recall the same, that she said his eyes were low. So you can figure out where exactly, 2040, 2030 something. But my direction is, since the discussion about being high has a clear pause before it, this is one of the benefits of Ms. Mathis talking the way she does. But if we go back 20, 30 seconds, no one was saying anything. And then she makes this pronouncement. Curtis Higginsbottom was high. So from just before that to just leading up to her saying his eyes, he came in, his eyes were low. I'm asking you either to mute it or you jump across. If you're just going to hit play and let it go, be ready at whatever that first hash mark would be, 20 minutes and some number of seconds, to mute it, or to, if it's easy enough to move the counter, then you can move it to 20, whatever. And just show Ms. Feely before we start up tomorrow where you're stopping and then restarting. But as long as it's consistent with what we talked about, then that's the only area Ms. Feely has identified. She's going to give it a listen one more time tonight. And she'll send you an email tonight, not wait till tomorrow morning, saying, I'm concerned about 30 minutes and 10 seconds. And here's why. So that when we reconvene in the morning, you know exactly where in the video and what her concern is, and you'll be in a position to say, we agree, we'll cut it, or no, this is essential. This is where she's talking about count one. This is the only evidence we have of count one. It's highly probative. Okay. Does that work for you, Ms. Feely?
Yes, Your Honor.
All right. So for now, as I take it, no other concerns from the defense about the video being unduly prejudicial or irrelevant pieces coming in.
I don't believe so. I'm going to hopefully be able to rewatch it this afternoon, but nothing is, I've watched it obviously numerous times. And
Sure. Okay. Mr. Jordan, you all might want to try one more time picking a spot. It was hard to hear Serenity. It's always going to be hard to hear Serenity, but there were some things that were a little mumbly and hard to pick up. You can do it there. You may try putting the speaker at the prosecution microphone so you can bend it right next to it. I don't care where you put the speaker, as long as we get the highest fidelity sound, which isn't necessarily the loudest. It's also tricky, like with that jail call, because Monique Mathis was super loud, such that it almost was feedback each time she started talking, and Mr. Higginsbottom was very, very quiet. Not that you're playing that tomorrow, but you may want to, when I leave here, try a little bit more with it, just to maximize. It will be frustrating to the jurors if they're having to do this and signal to us we can't hear what's going on. So food for thought. Ms. Feely, did you get any input from the appellate team about a basis for calling Ms. Harding?
I have not.
Okay,
I've not answered my emails.
let's revisit it in the morning.
It shouldn't take long.
Okay. So you can stop the share.
Yes, sir.
Anything else from the state?
Your Honor, Eddie Atkins will handle the announcement.
Your Honor, just out of an abundance of caution, the state was going to play in closing the jail call used for impeachment. The state, impeachment can come in as substantive evidence. Just wanted to be crystal clear for both defense and the court that the state does just intend on playing that as part of the closing argument, Your Honor.
How long was the call? I don't remember how long it was. You're playing just a part of it, or you're going to play the whole? Well, obviously you can't play the beginning of it.
Yes, Your Honor. We were going to play a part of it, Your Honor.
Okay. And you're going to figure out the technology so that it might be audible to the jury.
Correct, Your Honor.
Okay. All right. And that was states 29.
Yes, sir.
Correct, Your Honor.
Okay. All right. Anything else from the state?
No, Your Honor.
And you all are ready to, you'll be ready to go with closings. We could get to closings very shortly after you rest. We'll have a motion for directed verdict. I'll rule on that. I think at worst for the state, it might blow up 2 counts, but it sure seems like a couple counts at a minimum are going to the jury. So you all should be ready to go with your closing, just given the time we lost today. So we can try to catch up a little bit.
Yes, Your Honor. The state will be prepared, and we will make sure that the audio is as loud as it possibly can be and as clear as it possibly can.
Okay. Ms. Feely, anything more on behalf of Mr. Higginsbottom?
No, Your Honor.
My project, other than cleaning up the jury charge, will be to hear from Deputy Gordon about how the medicine administration went at Jail Medical. Tomorrow afternoon is going to be messy. What was the other reason why? Give me 1 second. So President Trump is coming in later in the day to go get booked in. So that's not here, but it affects roads because he doesn't walk. And then there is allegedly going to be a Cop City protest. None of that shuts us down, but it just, life is complicated outside. It's all late in the day, so it shouldn't affect any witnesses' ability to get here in the morning or our jurors' ability to get here in the morning. But if one of you was thinking, oh, and at 4:30, I'm going to try to get this into the courthouse, it could just be complicated because surface streets may be complicated. My hope is that by 4:30, the jury is deliberating if they're not done. Okay. If there's nothing else, you are all free to go. You may want to mess with the sound system. So
Yes, Your Honor.
you still here?
No, we'll see you up.
We're done. All right. I will end the Zoom. Are you able to set up your own Zoom to test it, or how do you test?